make presumption, that is a presumption which is a kind of a light presumption, meaning that the court may presume means may not also. As far as shall presume is concerned, it's a very strong presumption because if you go into the previous provisions of dowry debt and 498A, there were provisions where the court, there was evidence in the context of woman within 7 years of marriage was subjected to systematic ill treatment and thereafter dies in an unnatural way, then the court shall presume that the husband and in-laws were involved or abetted that different type of suicide or unnatural death. So that is shall presume. Now shall presume also means there is a scope of rebuttal on the part of the other party. But conclusive presumption is a presumption where the court is not going to even allow you to rebut. So one of those type of conclusive presumption includes section 112, where it's a question of legitimacy. That means the child basically is considered to be the child of the mother and the father. Now there is scope on the part of the father disowning, saying that the child is not the child of the father. But there lies the question of testing the fact of access. That means whether the husband and the wife they had access in that period of time, and also the question of minimum period that is required to conceive a child, like around 280 days or 9 months or whatever. Now the thing is, in Gautam Kundu versus State of West Bengal, it has been said that DNA evidence basically is a very valid evidence, very foolproof evidence of the fact of paternity. But only trouble lies in the fact that in case of DNA, let's say if a case happens where the father doesn't want to give the sample, doesn't want to give the blood, doesn't want to give the DNA sample, there are judgments like Selby versus State, which is a Supreme Court judgment, where it said that when you are giving an evidence which is self-incriminatory in nature, the court cannot, generally compel you to give such a kind of evidence. So in that perspective, 112 is very serious provision down the line. But having said that, again, India is basically an adversarial country. Always, it is considered better that a person is not punished rather than innocent person should not go behind bars. In that perspective, wherever there are doubts always go in favor of the defense and never goes in favor of the prosecution. So that's a pity. So for that reason, DNA evidence, which I am talking about the fact that Gautam Kundu versus State or Pushkar versus State has said that it's a very foolproof evidence. In spite of that, generally the defense tries to argue saying that it's of corroborative in nature. That means based on the sole testimony of the DNA evidence, one cannot be convicted. Along with the DNA evidence, there is the requirement of collateral.